The Supreme Court's interpretation of national versus state sovereignty. The landmark case of McCulloch versus Maryland in 1819 exemplifies a Supreme Court ruling that established the use of implied powers to expand the national government's enumerated authority. The case stemmed from Congress's establishment of a national bank, and in particular, a branch of that bank located in the state of Maryland, which the Maryland state authorities tried to tax. Attorneys for the state of Maryland argued that if the federal government had the authority to establish a national bank and to locate a branch in Maryland, then Maryland had the power to tax the bank. On a more basic level, Maryland's legal counsel asserted that Congress did not have the authority to establish a national bank, noting that doing so was not in the enumerated powers. Lawyers for the national government, in turn, argued that federal authority to establish a national bank was implied and that Maryland's levying a tax on the bank was unconstitutional, for it impinged on the national government's ability to fulfill its constitutional responsibilities by taking some of its financial resources. The Supreme Court decided in favor of the national government. The justices based their ruling on the interpretation of the Constitution's necessary and proper clause and the enumerated powers of Congress to lay and collect taxes, to borrow money, and to regulate commerce among the several states. The court said that combined, these powers implied that the national government had the authority to charter a bank and to locate a branch in Maryland. Moreover, the court found that Maryland did not have the right to tax that bank because taxation by the state would interfere with the exercise of federal authority. In addition to establishing that the necessary and proper clause justifies broad understandings of the enumerated powers, the court affirmed once and for all that in the event of a conflict between national legislation, the law chartering the national bank, and state legislation, Maryland's tax law, the national law is supreme as long as it is in compliance with the Constitution's enumerated and implied powers. A few years later, in the case of Gibbons versus Ogden, 1824, the Supreme Court again justified a particular national action on the basis of the implications of enumerated power. The Gibbons case was the first suit brought to the Supreme Court seeking clarification on the constitutional meaning of commerce in the Constitution's clause on the regulation of interstate commerce. The court established a broad definition of commerce, all commerce, intercourse meaning all business dealings. The conflict in this case concerned which government, New York State or the national government, had authority to regulate the operation of boats on the waterways between New York and New Jersey. The court ruled that regulation of commerce implied regulation of navigation and that therefore the national government had authority to regulate it, not New York State. Following the Gibbons decision, the national government frequently justified many of its actions by arguing that they were necessary to fulfill its enumerated powers to regulate interstate commerce, and the court typically agreed. In the case of United States v. Lopez 1995, however, the court's recent trend of being more critical of Congress' attempts to use the Commerce Clause to justify a national law. The context for the case is the National Gun-Free School Zones Act of 1990, which mandated gun-free zones within a specified area surrounding schools. The lawyers for Alfonso Lopez, a 12th grader charged with violating this national law by bringing a .38 caliber handgun to school, successfully argued that the law was unconstitutional. The court rejected the national government attorney's argument that the 1990 law was a necessary and proper means to regulate interstate commerce. Instead, the court found that the law was a criminal statute for which the state governments, not the national government, have authority. So what are your thoughts on that? Think about that for class. Another enumerated power that has expanded through court interpretation of what the Constitution implies is the power of the national government to provide for the national welfare. The national government's landmark Social Security Act of 1935 was a response to the Great Depression's devastating impact on the financial security of countless Americans. The congressional vote to establish Social Security was overwhelmingly favorable. Yet the constitutionality of this very expansive program, which has become the most expensive national program, was tested in the courts shortly after its passage. In 1937, the Supreme Court had to decide: was Social Security indeed a matter of general welfare for which Congress has delegated the authority to raise and spend money? Or was Social Security a matter for the state governments to address? The court found the national policy to be constitutional, a reasonable congressional interpretation, the justices wrote, of the enumerated and implied powers of the national government. The Supreme Court's decision in the McCulloch, Gibbons, and Social Security cases set precedents for the expansion of national power in domestic policy matters by combining the necessary and proper clause with such enumerated powers as the regulation of commerce and providing for the general welfare. The Court continues today to support Congress's use of the elasticity provided by the implied powers clause to expand its delegated powers. The Court also continues to protect national enumerated powers. Yet Congress does not always get its way, as the Justice's decision in the Lopez case indicates. In addition to establishing dual sovereignty and creating two independently operating levels of government, the Constitution enumerates some obligations that the national government has to the states. In Article 4 of the Constitution sets forth obligations that the states have to one another. Collectively, these state-to-state obligations and the relationship they mandate are forms of horizontal federalism. For example, state governments have the right to forge agreements with other states, known as interstate compacts. Congress must review and approve interstate compacts to ensure that they do not harm the states that are not party to them and the nation as a whole. States enter into cooperative agreements to provide services and benefits for one another, such as monitoring paroled inmates from other states, sharing and conserving natural resources that spill over state borders, such as water, and decreasing pollution that crosses state borders. States also cooperate through a procedure called extradition, the legal process of sending individuals back to a state that accuses them of having committed a crime and from which they have fled. The Constitution establishes a state governor's right to request the extradition of an accused criminal. Yet the courts also have supported governors' refusal to extradite individuals. The Constitution asserts, too, that each state must guarantee the same privileges and immunities to all U.S. citizens, that is, citizens from other states who visit or move into the state that it provides its own citizens. This guarantee does not prohibit states from imposing reasonable requirements before extending rights to visiting or new state residents. For example, states can and do charge higher tuition costs to out-of-state college students. In addition, in many states, new state residents must wait 30 days before they can register to vote. Yet no state can deny new state residents who are U.S. citizens the right to register to vote once they meet a reasonable state residency requirement. Today, one very controversial state-to-state obligation stems from the full faith and credit clause of Article 4, Section 1 of the Constitution. The full faith and credit clause asserts that each state must recognize as legally binding, that is, valid and enforceable, the public acts, records, and judicial proceedings of every other state. For example, states must recognize the validity of out-of-state driver's license. Currently, public debate is ongoing about the impact of the full faith and credit clause on same-sex marriage contracts, and hence the constitutionality of the National Defense of Marriage Act of 1996, which allows states to determine whether they will recognize same-sex marriage contracts or same-sex civil union contracts legalized in other states. President Obama's Justice Department is also reviewing the constitutionality of DOMA, which is the Defense of Marriage Act. The debates over same-sex marriage and civil unions raise several challenging constitutional questions. Because the Constitution is supreme, answers to those questions will eventually come from the Supreme Court's interpretation of the Constitution. Recently, the Supreme Court ruled that although the Constitution is the supreme law, state and local governments can guarantee their citizens more liberties and rights than are found in the Constitution, which guarantees only the required minimum. Political scientists use the phrase new judicial federalism to describe the practice whereby state judges base decisions regarding citizens' legal rights and liberties on their state constitution when those laws guarantee more than the minimum rights or liberties enumerated in the U.S. Constitution. In fact, many state and local governments grant more liberties and rights than the Constitution guarantees, and can do so according to the Supreme Court. New judicial federalism expands the authority of state governments in an era when the Supreme Court is ever more frequently being asked to clarify the constitutional distribution of authority. As we have seen, the delineation among national powers, enumerated and applied, and the states' reserved powers has never been clear. To complicate matters, over the course of U.S. history, national, state, and local governments' interactions have evolved into collaborative efforts whereby the creation, financing, and implementation of a given public policy are shared by two or more levels of government through intergovernment relations.